Please be seated.
Good morning, Your Honor.
Good morning. All right, this is the case of the State of New Jersey versus Paul Caneiro, dockets W2018-581304 and W2018-790-1337. All right, your appearances, please.
Good morning, Your Honor. Chris Decker, Assistant Monmouth County Prosecutor for the state.
Good morning, Your Honor. Mitchell Ansell, Grimm and Aaron, Paul Caneiro.
Good morning, Your Honor. Robert A. Honecker, Jr. from the firm Ansell, Grimm and Aaron on behalf of Paul Caneiro.
Thank you.
All right, thank you. Very good. We will begin with a reading of the defendant's rights. Mr. Caneiro, you are here today because you have been charged with an indictable or disorderly persons offense. This opening statement is designed to inform you of your rights and the procedures for today. Please listen carefully. I will begin with a reading of your rights. You have the right to remain silent. Any statement you may make may be used against you. You are being represented by a private attorney today. If that should change and you ever want to make application for a public defender, you have the right to do so. If you are not a United States citizen and if you plead guilty to or are convicted of certain offenses, including some motor vehicle offenses, it may result in your being deported from the United States, or it may prevent you from being readmitted into the United States if you leave voluntarily, or it may prevent you from ever becoming a naturalized citizen. You also have the right to seek advice from an attorney about the effect a guilty plea will have on your immigration status. You also have the right to pretrial release. You may be released today with conditions unless the prosecutor has filed a pretrial detention motion or if you have outstanding detainers that cannot be resolved today. If the state has filed a motion for pretrial detention, then and they have, and your case will be heard, it's going to be consolidated and heard today to determine whether you may be safely released or must be detained pending trial. At that hearing, the state must establish probable cause that you committed the alleged offense. You will have the right to an attorney, and you do have an attorney representing you here today. You will have the right to testify, to present witnesses, to cross-examine witnesses who may appear at the hearing, and to present information by proffer or otherwise. Testimony given during the hearing shall not be admissible against you on the issue of whether you are guilty, but your testimony may be admissible in proceedings related to pretrial release, violations of the conditions of release, perjury, or for purposes of impeachment. Under the court rules, the state can request a 3-day postponement of the detention hearing. You may request a 5-day postponement of the detention hearing. While awaiting the hearing, your commitment to the county jail will be continued. If the state withdraws its motion before the hearing, you will be brought back to court and released on your own recognizance or with the conditions of release. However, if the prosecutor has not filed a motion for pretrial detention and you do not have any outstanding detainers, you will be released on your own recognizance or with conditions of release. As a condition of release, you must provide a valid mailing address at which you receive and regularly check mail. You must notify the court handling your case of any change of address. If you fail to notify the court of any change of address and miss a court appearance as a result, a bench warrant may issue for your arrest. Please provide court staff with your mailing address, cell phone number, home phone number, email address, and the best way to reach you in the event that the court staff must notify you of a change to your scheduled event. In addition, the court may assign other conditions of release. You must strictly adhere to these conditions. Failure to do so may result in a bench warrant being issued for your arrest or the revocation of your release. If you are charged with an indictable offense, you have the right to have a hearing as to probable cause and the right to indictment by the grand jury and trial by jury. You may also choose to waive an indictment or a trial by jury. If you choose to waive a trial by jury, you will be tried by the court. In that instance, a judge will determine whether you are guilty or not guilty. You may be eligible for the pretrial intervention program. You may also be eligible for the drug court program. In order to be considered by these programs, you must submit an application. Staff in the courtroom will direct you to relevant materials for making these applications. A special note for military veterans, a program called the Veterans Assistance Project exists to provide veterans with referrals to community-based resources for services related to housing, mental health counseling, substance abuse treatment, financial aid, legal services, education, and veterans benefits, including possible monitoring by another veteran. Our court staff can provide you with a brochure describing the program and an application. Staff can also help you with completing the application. All right. That concludes the statement. I would ask that the prosecutor read the charges.
Thank you, Your Honor. Mr. Caneiro, first and foremost, warrant 2018-00079013-7 alleges that on or about November 20th, 2018, you did commit the crime of aggravated arson, specifically by purposely or knowingly placing another person in danger of death or bodily injury, and/or with the purpose of destroying a building or structure of another. To wit, you did set fire to your residence by using gasoline, igniting the gasoline, causing the residence to catch fire while your wife and 2 daughters were inside. That is in violation of NJSA 2C 17-1A1 and/or A2. Here is a copy of your complaint.
Record will reflect the defendant has been served a copy of the complaint.
Thank you, Judge. And Mr. Caneiro, W 2018-000058-1304, alleges that also on or about November 20th, 2008, within the jurisdiction of this court, you did purposely or knowingly cause the death of Keith Caneiro or serious bodily injury resulting in the death of Keith Caneiro. That's a first-degree crime, contrary to NJSA 2C 11-3A1 or 2. It also alleges that within the jurisdiction of this court, you did purposely or knowingly cause the death of Jennifer Caneiro or serious bodily injury resulting in the death of Ms. Caneiro, a first-degree crime contrary to the same statute. The third charge is that you did purposely or knowingly cause the death of J.C., a juvenile, or serious bodily injury resulting in the death of J.C., also a first-degree crime. The final murder charge alleges that you did purposely or knowingly cause the death of S.C., a juvenile, or serious bodily injury resulting in the death of S.C., crime of the first degree. You also are charged with purposely starting a fire on the property of another, to wit, 15 Willowbrook Road in Colts Neck, New Jersey, owned by Keith Caneiro and/or Jennifer Caneiro, thereby purposely or knowingly placing another person in danger of death or serious bodily injury, or with the purpose of destroying a structure of another. This is a second-degree crime contrary to NJSA 2C 17-1A1 and/or 2. You also are charged with a second-degree crime of possession of a firearm for an unlawful purpose, by purposely or knowingly possessing a firearm with the purpose to use it unlawfully against the persons of Keith Caneiro, Jennifer Caneiro, Sophia Caneiro, or Jesse Caneiro. Finally, you are charged with unlawful possession of a knife for an unlawful purpose, a third-degree crime for using it unlawfully against the person of the aforementioned victims. Judge, that culminates the reading of the complaints. I will provide this last warrant to Mr. Caneiro.
All right, record will reflect that the defendant has been served with a copy of that complaint as well. Defense want to add anything at this point? before we
Judge,
proceed?
at this point, we acknowledge that my client has been served in regards to these particular complaints and ask that a not guilty plea be entered in regards to all of these complaints.
All right, so noted. All right, we are joining today the first appearance along with the probable cause and the detention. How will the state be proceeding as the probable cause?
Judge, our intention was to proceed by way of proffer with respect to both detention motions. However, I've had conversations with Mr. Ansell and Mr. Honaker with respect to this. And it's my understanding that based upon the discovery they've received and the knowledge they have of the case, they are going to be stipulating that probable cause does exist based upon the discovery as of now, and it's for purposes of this motion or this detention motion, or both detention motions at this time. That being said, it's also my understanding that once that probable cause determination is stipulated there too, they will be consenting to Mr. Caneiro's detention, continued detention, through the culmination of these matters. That is my understanding. Mr. Ansell and Mr. Honaker, I believe, would agree with those representations.
All right, Mr. Honaker, Mr. Ansell, is that your understanding?
That's correct, Your Honor.
It is, Your Honor.
In regards to this particular matter, we will not contest probable cause at this juncture. We stipulate the probable cause at this juncture, but reserve the right to challenge probable cause should there be any additional motions, such as motions to suppress evidence or motions to dismiss the indictment.
All right, very good. Probable cause, as we know, is a well-grounded suspicion that an offense has been committed and that the defendant committed it, and that's State v. Sullivan, 169, New Jersey 204. I will accept the stipulation of probable cause, and we will move on to the detention phase of the proceedings. It is my understanding that detention is being consented to. That is correct?
That's correct, Your Honor.
Exactly, Your Honor.
We've had an opportunity to fully advise our client as to the nature of the detention hearing. Our client has indicated that he wishes to consent and waive his opportunity to have a detention hearing, and we've advised the prosecutor's office of our decision in that matter.
It's accurate, Judge.
All right. Well, at this point, I'm going to place him on the record and read to him his rights that he would have had the detention hearing proceeded, so that the record will reflect that there is a knowing and voluntary waiver of the rights. Please stand, sir.
Place your left hand on the Bible. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record and spell your last name.
Paul Caneiro, C-A-N-E-I-R-O.
All right. Mr. Caneiro, you have the right to be present at this hearing, which you obviously are. You have the right to have counsel, which you do. And at a detention hearing, you also have the right to be provided with all statements or reports in the prosecutor's possession relating to the facts on which the state bases its pretrial detention application. Mr. Decker, have you provided all this information to the defense?
Judge, I have. We've provided on several occasions over the course of the last, I think, 10 days. It's my understanding that anything that's been potentially exculpatory would have been turned over, but I don't believe that there is any at this point.
All right. You also, sir, have, Mr. Caneiro, have the right to be furnished with all exculpatory evidence. That's evidence that would tend to exonerate you, known to or in the possession of the prosecutor. Mr. Decker, you have provided that as well, all exculpatory evidence known to you in your possession?
Yes, Judge, I have.
All right. You also have the following rights at this hearing, sir. You have the right to present witnesses, you have the right to cross-examine any witnesses who may appear at this hearing, and you have the right to present information by proffer or otherwise. You understand each of these rights, sir?
I do.
All right. You also have the right to testify at this hearing. You do not have to testify if you choose not to do so. If you do elect to testify, your testimony shall not be admissible on the issue of guilt in any other judicial proceedings. Do you understand that, sir?
I do.
I should advise you, however, that if you do elect to testify at this pretrial detention hearing, your testimony shall be admissible in any or all the following proceedings. Any proceedings related to your subsequent failure to appear when required, if applicable. Any proceedings related to any subsequent offenses committed during the release, if applicable. Any proceedings related to your subsequent violation of any conditions of release, if applicable. Any subsequent perjury proceedings, if applicable. And for the purpose of impeachment in any subsequent proceedings, if applicable. Do you understand your right to testify or not to testify, as the case may be?
I do.
Has your attorney explained each of these rights to you?
Yes.
Has your attorney answered all of your questions regarding your rights at the detention hearing?
Yes.
Do you need any more time to speak with your attorney about the detention hearing and your rights at the hearing?
No.
All right. Counsel for the defense, have you explained each of these rights to your client?
We have, Your Honor.
All right. Are you satisfied that he understands these rights?
Yes,
Have you reviewed with your client the information provided by the prosecutor?
we have.
And have you had enough time to discuss this matter with your client?
We have.
All right. Now, one more thing, Mr. Caneiro, is anyone forcing you to waive this pretrial detention hearing?
No.
Are you under the influence of any drugs or alcohol today?
No, I'm not.
Do counsel have any additional questions relative to this waiver of the detention hearing?
No, Your Honor.
No, Your Honor.
Okay. State, have any further questions?
I do not. I'm satisfied.
All right. I'm satisfied that having read the defendant his rights that he would have had at the pretrial detention hearing, that he's knowing and voluntarily waiving his rights, and I will direct that he be detained. All right. Anything else from counsel? No?
No, Your Honor.
All right.
No, Your Honor.
That will conclude the matter.